there are many similarities, I admit, between my bill and Delegate Carr's and Delegate Simon's. I should note that the provision in the code 18.2-251, it has been around at least since 1950. I don't know that it's been in exact these terms, but it's quite onerous that even on a first offense, on probation, for something as simple as possession of marijuana, you have to enter a treatment and an education program or service. You have to pay for all the costs of that. You have to do community service. You have to be alcohol-free during all your probation. You lose your driver's license. And notwithstanding all of that, I think the people who put this code in way back in 1956 years sort of understood that you have a first offense, nobody's perfect, and as the witness for Delegate Carr talked about, this can follow you around for the rest of your life, 30, 40 years. It seems to me that if we're allowing people to understand they make one mistake in their life, it's just possession, it's nonviolence, just possession of marijuana, to apply with discretion of the court to get rid of this on the record. I should note in answer to the question that was asked Delegate Simon, the state police, according to HB 996, would keep a record of this. So this would not be hard to find for a Commonwealth attorney. It would not be hard to find for the military. It would, however, allow someone like a constituent of mine to apply for a job at Starbucks, where they're not facing enemy fire, they're facing coffee. And one of the main things about this problem is that we have people who make one mistake in their lives and they become practically unemployable, even at entry-level jobs. And I don't think it helps the Commonwealth to say that someone who's made such a limited mistake that we're not even going to have a conviction under the code should be basically unemployable for the rest of their life, even at some very common-level jobs. It leads people to go on public assistance. It's not good for the Commonwealth. And frankly, I think the purpose of 18.2-251 is to recognize that we want to rehabilitate these people, not declare them criminals for the rest of their lives. It also would include a simple conviction, again, for possession of a controlled substance. If this committee wanted to limit it to only 18.2-251, I'd be fine with that.
Mr. Chairman.
Okay. Delegate Klein.
So you're aware that this is not just limited to marijuana at this point?
It's possession of marijuana or a controlled substance under 18.2-250, a misdemeanor, nonviolent possession, not sale, nothing like that.
Okay. Is there anything at this point prohibiting Starbucks from hiring the individual you're talking about?
There's no law requiring it. However, Starbucks can ask, and the Supreme Court case, Commonwealth v. Dodson, basically says that it cannot be expunged. They can ask if someone's been arrested, and again, this committee's vision that someone who has one nonviolent drug possession violation in their life should have to answer these questions for, like the gentleman that spoke on behalf of Delegate Carr, for 30, 40 years later. I think that's a penalty too harsh for something that, let's face it, I think it's fair to say that perhaps 50% or more of the Commonwealth has broken this law, and they just haven't all been caught. It's very, very common. I think prohibition has failed, and I don't think that this is something that should lead someone to be jobless the rest of their life.
Further questions?
Delegate Klein.
I'm looking at this last sentence of Section B that says that an expunged conviction can be considered a prior conviction for purposes of subsequent offenses.
That's correct.
You're an attorney, correct?
I am, although not a Virginia attorney.
Can you tell me how that's possible?
Sure.
To consider an expunged offense that is not allowed to be public and would in fact be made criminal. There would be a criminal charge if that information is released to be used in a subsequent charge.
Sure, it would be maintained by the state police and the Department of State Police, so it would be attainable throughout the Commonwealth. And judges and Commonwealth attorneys could use it. I should note that under 18.2-251 right now, you can't use this twice. So already the records are kept with regard to a subsequent offense. I have no problem with saying that this is just one bite of the apple. You don't get two. I have no problem with if someone makes a mistake twice, that they suffer the full penalty of the law. And if you have a way to revise this to make sure that's the case, I have no problem with that friendly amendment. The purpose of this is not to stop Commonwealth attorneys, it's not to stop courts, it's to basically allow an entry-level job for someone who has a very minor offense.
Any other questions for the paper? Any member of the public like to be heard?
I believe Dr. Pamela Novi, she'll introduce herself.
Hi, ma'am. Tell us your name, tell us your thoughts on the bill.
My name is Pamela Novi. I'm a graduate of Old Dominion University. I have a PhD in clinical psychology from the University of Vermont. I served as a psychologist in the military. Prior to that, an electronics technician. I served in Iraq and Afghanistan as a combat operational stress psychologist. The reason I'm here advocating for this bill is because I currently am the executive director of Virginia Normal. And the reason I found myself in this position is that my son was arrested several years ago. When he was in his first year in college, I was on a remote assignment in Korea. He was in a Taco John's parking lot, this was not in this state, splitting up half an ounce of weed with a couple of other guys and got arrested. He now has actually a felony on his record. First of all, this derailed his life for at least a couple of years and continues to be a challenge to have that on his record. Now, since I've become the director of Virginia Normal, I've had many, many people talk to me about their sons and their grandsons who have experienced similar events, and how laws like this, where we cannot expunge these records, do affect them for the rest of their lives. These are not just young people who just want to go out and get into trouble who are asking for this. It's mothers and parents of these children. We wind up with them in our basement, living with us for years because of these kinds of things. So we're asking that you really take a close look at all of these expungement bills and come up with something good that will help people like my son in Virginia.
Thank you. Anybody have any questions for the speaker? Any other member of the public like to be heard?
Mr. Chair,
Delegate Gilbert.
I move to lay the bill on the table.
Motion has been made to table the bill. Is there a second? All in favor signify by saying aye. Aye. Opposed? No. Thank you, Delegate. All right, we have two from Delegate Heritage.